In cross-border estates involving Vietnam, one question defines everything. Which law applies to the inheritance? Vietnamese inheritance law, or the foreign law of nationality or domicile? The answer is rarely simple. Many foreign nationals assume that their home country law governs their entire estate worldwide. Under private international law, that assumption may be incomplete. Asset location often matters more than nationality. For immovable property, including land use rights and houses in Vietnam, Vietnamese law generally applies. This principle is widely recognized in international practice. Real estate is governed by the law of the place where it is located. Vietnam's land regime is unique. Land is owned by the state and individuals hold land use rights. Succession of these rights is governed by Vietnamese law, regardless of the testator's nationality. For movable property such as bank accounts, shares, or personal assets, conflict of law analysis becomes more complex. For movable property, Vietnamese conflict of law rules may consider factors such as nationality, depending on the nature of the asset, requiring each asset to be assessed individually. Vietnamese civil code includes provisions addressing inheritance involving foreign elements. These rules determine when Vietnamese law applies and when foreign law may be considered. Mandatory domestic provisions remain decisive. Some wills include a clause selecting foreign law to govern succession. Such clauses may be recognized in certain contexts. However, they cannot override mandatory Vietnamese rules, especially concerning immovable property and compulsory heirs. Vietnamese inheritance law protects certain heirs through compulsory share provisions. Even if foreign law is chosen in a will, Vietnamese courts may apply domestic protections to assets located in Vietnam. Public policy boundaries remain in place. Where the deceased held dual nationality, legal analysis becomes even more nuanced. Vietnamese authorities may examine habitual residence and asset location. Conflict of law principles require structured evaluation. Some jurisdictions prioritize habitual residence over nationality. Vietnamese law may consider both factors depending on asset classification. Assumptions based solely on passport status are insufficient. Assets located outside Vietnam are generally governed by the law of their location. Vietnamese courts typically do not assert authority over foreign real estate. However, domestic inheritance disputes may still affect global distribution. In multinational estates, different parts of the estate may be governed by different laws simultaneously. Vietnamese law may govern local real estate. Foreign law may govern overseas assets. Coordination is essential. Even if foreign law governs part of the estate, enforcement in Vietnam requires domestic procedural compliance. Recognition of foreign probate decisions is a separate legal process. Governing law and enforceability are distinct issues. Shares in Vietnamese companies are generally subject to Vietnamese corporate and inheritance law. Even if a will selects foreign law, corporate registration requirements follow Vietnamese statutes. Operational reality prevails. Different governing laws may create parallel tax obligations. Inheritance planning must consider both Vietnamese reporting requirements and foreign tax exposure. Fragmented planning increases financial risk. In certain circumstances, Vietnamese courts may apply foreign law to movable assets if conflict of law principles permit. However, proof of foreign law content may be required. Failure to establish foreign law may result in default application of Vietnamese law. Unclear governing law increases litigation exposure. Heirs may argue for different legal systems to maximize advantage. Ambiguity encourages dispute. Cross-border estate planning should identify asset location, assess applicable conflict of law rules, and align wills accordingly. Dual will structures may reduce friction. Clarity limits opportunistic challenges. For foreign investors and multinational families, the question is not which law ideally applies. The question is which law will actually control each asset category in practice. Structure must reflect operational reality. In estates involving Vietnam, asset location and mandatory domestic provisions often determine the governing law. Nationality alone does not control the outcome. Effective cross-border estate planning requires deliberate alignment between Vietnamese inheritance law and foreign legal systems. Without that alignment, courts will decide. If your estate involves Vietnam and another jurisdiction, do not assume a single legal system will control everything. Under Vietnamese law, asset location and mandatory provisions often determine which rules apply. To assess which law governs each part of your estate and structure your planning accordingly, contact LTS Law at lts.com.vn for strategic cross-border legal guidance. In multinational estates, clarity does not happen automatically. It must be designed.